Hey everybody, it's your girl, Miss Public Info here on Castle Court TV, here with the latest and greatest and sometimes hated updates of the most high profile cases going on around the country. Thanks so much for joining me today. So glad to see you guys, even though I don't see you, but you see me. So glad that it's good to be seen. Let's just say that. Thanks so much, everybody, for joining me. We have an info packed day, and it looks like it's going to land on the Bad Boy Entertainment side. There's a few updates I want to give. Some of this is directly having to do with Sean Combs, and some of this has to do with one of his children's mothers. Okay, so we have an update as to the response to the Department of Justice's denial of Diddy's request to receive an acquittal or a new trial. So we're going to go through that. We're also going to go through developments and updates in court today that occurred between Sean Combs's attorneys and the attorneys for Anna Kane. She is the former Jane Doe who is suing Sean Combs and former Bad Boy senior executive Harve Pierre in this civil sexual assault case that she filed back in 2023, claiming an assault occurred in 2003. Next, we're going to talk about a lawsuit that has been filed against Mary J. Blige. Of course, I don't have to tell you guys about the connective tentacles between Mary J. Blige and Sean Combs, but that lawsuit was brought by Misa Hylton, who is the mother of Sean Combs's oldest son, Justin Combs. So this is all going to get really murky today. I'm going to assess through this, and we're going to talk about the developments in each case and what is actually going on. Let's start it off. Now, Sean Combs, his legal team responded yesterday. I believe it was after I did the episode on my episode yesterday, so I wasn't able to include it. But late in the afternoon on the East Coast yesterday, Sean Combs's team responded to the Department of Justice's response to Diddy's team's request for a new trial or an acquittal. And essentially, Sean Combs's team said that, listen, this thing needs to be retried. He deserves an acquittal because of the fact that this thing has been defined incorrectly. Now, they are claiming that the Department of Justice defined prostitution as a definition that was a former definition than what it was when it was actually passed. The law for prostitution was passed 115 years ago. Now, I want to be clear on this. Now, he's saying that, listen, if the definition is wrong, then the whole thing is wrong. Now, this is according to TMZ and according to legal documents that we have obtained here at Castle Court TV, that his attorneys submitted a new legal document arguing that the prosecution is using the wrong definition of the term prostitution. And in his criminal case, they are demanding that Judge Submaranian, which is the trial court judge, either acquit Sean Combs or grant him a new trial based on this specific term. Now, the Mann Act was also known as the White Slave Traffic Act, and it's a federal law that passed in 1910 that makes it a federal offense to transport or cause to be transported in an interstate or a foreign commerce any woman or girl for the purpose of prostitution. Now, his attorneys are arguing that the court should be using the 1910 definition of the word and not the 2025 definition. They're saying that, no, you're charging him based upon this act that was in 1910, but you cannot use the definition within this act that is based in 2025. You should be using the 1910 definition. They noted that in 1910, a prostitute was a woman who had sex outside of marriage against the prosecution's position, which suggests that prostitution is in and of itself sex for hire. And of course, this is going along with the fact that he's saying that he did not hire any of these escorts that came into this situation with he and Cassie, that these people were not hired for SEX. Now, of course, a few of the male escorts did actually testify, and there was one in particular who did say on the stand that he was hired for SEX services. Also, it was also revealed through voicemails that and text messages that Sean Combs was communicating with the actual escort service, that he wasn't pleased with the services that were rendered. The actual escort services said, well, what do you mean? He says it could, because, they're just there for company. And he said, well, no, this person, he could not even perform. So in and of itself, the prosecution basically says, well, he admits the fact that this performance, what do you mean performance? Sexual performance, that's what it is. They purported from that voicemail and presented to the court that, listen, he admitted to hiring these escorts for sexual purposes. And so that is the reason he was convicted, in part, rather, he was convicted of the Mann Act. And so, in layman's terms, his attorneys are saying, listen, we need to be going on the 1910, definition of this particular term, prostitution, and not the sex for hire, which would, in their opinion, which would torpedo the DOJ's case, because then, they wouldn't be able to say that, he actually committed prostitution based on the fact that the definition in 1910 was a woman having sex outside of marriage. And that was the reason they were transporting this woman. So now, my official opinion on this whole thing, obviously, I'm going to go with what I always say. I'm not a lawyer. I'm not a lawyer, but I do understand the legal processes. I don't think this is going to fly. Obviously, the law itself is an outdated law, but they were able, it's still on the books, so they're able to charge someone with it, and a court of his peers convicted him on that. Now, the term prostitution, it was stated in many different ways from the beginning to the end of this trial that Sean Combs was being tried under this particular definition. His attorneys had a lot of time, not only pre trial phase, but during the trial, to actually combat this definition, and they did not. So I believe that Judge Submaranian is going to sort of bat this down like the no-fly zone, my NFL term, because this is going to be, I mean, it's an effort, and they have to do it because they're his attorneys, and, it's an effort worth arguing. But is it an effort that's going to change the course of this situation? Is it going to help him, is it going to allow him to be granted a new trial or an acquittal? And my opinion is no, because they have had a lot of time to combat this in the court proceedings prior to now. There was so much that they could have issued. This is the same situation that went down with them when they actually went to Judge Submaranian about a few other things that had to do with Sean Combs and what they didn't discuss during the trial court phase. And Judge Submaranian said at that time, you all had a lot of time to, bring this to the court's attention, and you did not. And essentially, it is a chess or checker piece move to sort of allow their client to gain an advantage legally. That's what it is. But I do not think this is going to fly, and this is not based on my biased opinion on the case at all. This is based on the law, and the definition of prostitution of itself is that is exactly what they said, sex for hire. It was part of the trial. If Mr. Combs and his team had an issue with the definition during the course of the trial, during the time that people were testifying about the SEX for hire, when the DOJ was bringing up these voicemails about Sean Combs speaking to the escort service and bringing up proving up that he was hiring these escorts for sexual situations between he and Cassie. His team had time then to object. Then they did not, if I recall, did not bring this up in the Rule 49 argument either, where they had time to, when they brought those arguments forth saying, our client should be acquitted because of X, Y, and Z. There was not an argument made by Combs's attorneys regarding the actual definition of the term prostitution. They did not argue that. This is an attempt to gain an advantage. They are grasping at straws. It's their job. It's their job to defend their client. It's their job to appeal. It's their job. They've got to throw everything in but the kitchen sink and see what sticks. But this one doesn't stick. And that's what I'm thinking. So we will hear from Judge Submaranian up next. Both sides have had a chance to respond. The defense has had a chance to rebut the DOJ, which they are given that clearance because they're the original filer. And now, next, we are awaiting word from Judge Submaranian, and I think it's going to look a lot like this sort of, history of Combs sort of trying to get, granted a new trial or getting bail to get out of jail, where Judge Submaranian has said, you guys had time to do X, Y, and Z. You didn't make the effort. He said it with the bail. Listen, guys, you made the assertion during the trial court phase, during closing arguments, that your client was violent. And now that he is not going to be released from jail because of his propensity for violence under this act, where I am required, says so the guidelines of this act in which he was convicted of, I'm required to keep him remanded in the custody of the federal jail, federal prisons. Then now you're saying, oh, he actually isn't violent. So this is a lot of the tit for tat that the Combs defense has tried to play from the beginning, and Judge Submaranian has batted that down every single time. And I think we're going to see more of that with this particular answer from Judge Submaranian. Okay, so now we are going to move on to this this case with Sean Combs, that it's actually against, rather, Sean Combs and HARVE Pierre. So this is a situation. Let me pause this quickly. Sorry, guys. I want to, and I think I'm gonna have to do this again. I'm still getting the hang of like sharing my screen, this, that, and the third. It's all very strange here. I'm always trying to figure things out. Okay, so now this is HARVE Pierre and Sean Combs. This is the former senior executive member of the Bad Boy staff with Sean Combs. Now let's go through this. HARVE Pierre has a few lawsuits that include he and Sean Combs together, which it says a lot, right? So HARVE Pierre, he's been named in multiple lawsuits alongside Sean Combs as it relates to sexual assault. Now, the allegations against them include sexual assault and sex trafficking. The lawsuits were filed in late 2023 and 24, and they are part of this numerous legal actions against Sean Combs, which we know about. Now, one of them is the lawsuit by a former assistant. This person is unnamed, so this is likely a Jane Doe. I think it's a woman. I'm not sure. But this was filed in November 2023. And the allegations are that Pierre is accused of grooming, exploiting, and sexually assaulting his former assistant on multiple occasions between 2016 and 2017. And the co-defendants in this case are Sean Combs' companies, including Bad Boy Entertainment and Combs Enterprises. So this is an actual lawsuit with just Harve Pierre himself by himself. Then there is a lawsuit between that's being actually filed against Harve Pierre and Sean Combs by Don Richard. Of course, Don Richard, she is the singer, a member of the groups Danity Kane and Diddy Dirty Money. She also testified in the trial court phase of Diddy's case in federal case. Now, this was filed in September 2024, so just a year ago. Now, the allegations against Harve Pierre and Sean Combs are that she was accusing them of sexual battery, sexual assault, sex trafficking, and withholding millions in unpaid wages and royalties. Now, since she testified at trial, we have not heard anything about this particular case. We don't know what the update is here. The co-defendants in this case are other entities named include Combs' record label and Bad Boy Entertainment, and of course, Universal Music Group. Now, let's get to the present. The lawsuit that we're going to talk about today that has the updates. I just wanted to mention those two because I wanted to set some precedents and sort of peel out the fact that Harve Pierre has a history of being cornered, targeted for these lawsuits with Sean Diddy Combs. This is a pattern. Okay, now the lawsuit by Jane Doe, who we now know has been identified as Anna Kane. Now, at the time of the alleged assault, Anna Kane was 17 years old. She was identified as Jane Doe when this lawsuit was filed in December of 2023. Now, the allegations in this case is that Combs, Harve Pierre, and another unidentified man gang RAPE'd Miss Kane in 2003 at Combs' recording studio after plying her with drugs and alcohol. Harve Pierre is also accused of sexually assaulting her before the flight to New York that she took. Okay, now the co-defendants in the lawsuit names Bad Boy Entertainment, Daddy's House Recordings, which is the recording studio where this alleged assault happened, and an unnamed third assailant. Now, the legal status until today was that the judge had later ruled that if the lawsuits were to proceed, that the plaintiff would have to use her real name. And that is exactly what happened. She is using her real name. So let's talk about this development today. I'm going to be looking over here because I have another screen happening, and this is where the court session notes are. So I'll look back to and fro. So please don't think I'm crazy when I'm looking here. Now, today what happened in court was you had Combs's attorneys and you had Anna Kane's attorneys. That is her name. She wanted to continue the pursuit of this case. So given the judge's order, she had to use her actual name, and she did so. This was, if you can recall, one of the, in my opinion, one of the scare tactics or one of the demands of the Sean Combs defense team, that if she were to continue with this lawsuit against him and Harve Pierre and this third person, then she would have to reveal herself. And while Sean Combs has been in that jail holding facility, she said, fine, I will reveal myself. And she did. I'm going to hit a pin here because I want people to understand that this is sometimes, most of the times, used as a scare tactic to keep people who want to retain their anonymity from moving forward in a lawsuit. Usually, when this happens, a defense team will usually try to get someone to back off of a lawsuit by saying, well, you need to identify yourself, because the reasons for identifying themselves is likely for their own protection. Obviously, this is a very private and very sexually revealing case. And a lot of times they want to retain their anonymity because of the fact that this is just so embarrassing. It's so intrusive of their private life as something that happened to them, something traumatic that happened to them. Now, one of the grounds that Sean Combs's team stood on was the fact that she's no longer underage. She may have been 17 at the time in 2003, but this is a grown 30-something-year-old woman now. So if she wants to move forward with this case, then she needs to reveal herself. Now, she called their bluff. She didn't hide. And she said, fine, okay, I will reveal myself. The judge sided with Combs's defense team on that demand, and she went ahead with it. Now, and that tells you a lot. That means that this case has legs. It says that this young lady has some standing to go on. There's proof, and her team actually gets into that today with these developments. Now, there are some issues in the Second Circuit with regard to things going on, and so the Diddy's attorney, the defense attorneys, asked that the case be stayed, paused until these issues were uh, sorted out. And so Judge Clark asked if there could be a middle ground that the plaintiff's attorneys, Anna Cain's attorneys, will be willing to play ball with, meaning that allowing discovery to sort of gather so that they can, see what's up with the case. Now, her attorneys said, we have a Doe defendant here. So there's a third assailant. We need discovery to find out who they are, he said. The judge said, well, what does that discovery look like? Her attorney said, well, there are many allegations against Mr. Combs, similar acts that are likely to be admissible. They go on to say, it is unclear how many of the other victims we would seek to depose, meaning a deposition, to find out possibly who the third person was. They go on. But Mr. Combs and Mr. Pierre and the third assailant, once identified, we aim to depose. So he's letting them know. Once we identify this third person, we are going to depot Sean Combs, HARVE Pierre, and this third person. Now, again, I'm repeating this for those of you who are maybe new to my channel. First of all, welcome. But for those of you who are vets, I say this all the time when I talk about civil cases. Depositions are really scary for people because it is essentially what you do to expose inaccuracies, expose events, expose things that happen, and you do it under oath. This is usually done via video. If you were around during the O.J. Simpson days, you would have seen a videotape of O.J. Simpson being deposed on video for the civil case that Ron Goldman's family had out against O.J. Simpson. Is very, you can Google it and you'll see the video, but it's very similar to that. They depose the person on camera. The deposition, they are sworn in. They have to tell the truth. And they basically, this allows the party who is doing the deposing, meaning in this case, the plaintiff, which is Ms. Cain's attorneys, to basically question Sean Combs, question HARVE Pierre, question this third assailant under oath on camera, asking about this specific incident, asking about activities surrounding this incident, asking about specific witnesses or even potential other victims. So depositions are really scary. A lot of times during this phase, this is normally done during the discovery phase where you're sort of seeing what we have. This is why the judge talked about the discovery phase and why the attorney said, well, we need discovery so we can find out who the third person is, because discovery, hence the term discovery, is how you find things out. But it is normally during this phase where the deposition happens. And it's normally during this time where the discovery phase where settlements happen, because they know that their client is very much at risk of being deposed. And if they are deposed, if they are put under oath, then therefore they're going to have to come up with the truth. If they don't come up with the truth, once the case goes to trial and they bring back the records from the deposition, and anything that you say cross hairs with the thing in which you said when you were under oath, you can perjure yourself. This is very similar to what happened in the Cardi B trial, where the young lady who was claiming that Cardi B assaulted her, she said in the deposition that Cardi B scratched her nose, but when she was on trial, there on trial on the stand, she said that Cardi B scratched her face, and so Cardi B's attorneys tried to impeach her. They had grounds to do it. But so that's the reason why a lot of people don't like depositions, don't want to have their clients deposed, because they stand in a very dangerous waters of perjuring themselves, dangerous waters of even being impeached. So normally this is the time when someone is threatening with the deposition, this is the time where people will settle uh, out of court. So we'll see what happens there. But moving on. So her attorney goes on and says that a pause in the case, which is to delay or stay the case, rather, which is what the defense attorneys, Sean Combs' attorney, is asking for. He says this would hurt the case. He says that there may be 100 or more victims of Combs, but we will not depose all of them. Maybe 7 to start. So that means they already have names. They already have victims. They already have witnesses. They already have people identified that they are going to depose. They said, we're going to start with 7, but there may be hundreds. The judge says, well, could you limit by the time frame? And her attorney said, don't want to limit yet under 415. This happened in 2003. We could say 2000 to 2010. So basically, they don't want to limit their witnesses to people who or time limit in which this time frame were to supposedly have happened, where they would be allowed to sort of bring witnesses who within this time period either witnessed or had or was a victim during this particular time limit. He's saying 2000 to 2010, but they wouldn't want to limit beyond that, is what he's saying. That's the longest length that they be willing rather to limit. Her attorney goes on and says, if there's any chance of settling this case, you hear what I said? They're ready. He's like, are you ready to settle? Because I'm telling you what we're getting ready to do now. If there is any chance of settling this case, we need to access the other complainants. How many could testify? So discovery would help. Now, Combs' attorney says, is this case different than the other 12 in terms of the stay? And he says, no. Combs' attorney goes on to say the issue of whether these claims are timely is pending at the Court of Appeals. We're mindful of judicial resources. Absent the gender-motivated violence look back, this is not timely. He says this isn't timely. Your Honor disagreed with Judge Kaplan. Now it's at the second district. So these are the second district issues with the Court of Appeals on some other issue that they're talking about here. Combs' attorney says the plaintiff sued 20 years after the fact. The evidence was already stale, so the prejudice to plaintiff is not real. Discovery would be invasive, aka we do not want our client to be deposed. This is too intrusive. And he goes on, then it may be decided that the case is invalid. And so the judge says, well, I didn't stay Doe versus Black, which is, I guess, some case law precedents that he's calling out. He said there was no stay on revealing the plaintiff's identity. Tell me how you would be prejudiced. He's asking Combs' attorney. Combs' attorney said, well, we haven't talked based on his preview. We'll have significant disagreements about the scope. This is, he said, she said, from 2003, he says. And he goes on to say that much of the Doe versus Black docket is sealed, but it seems it is stayed for reasons not unrelated involving the Wigdor form. Now, Wigdor is Cassie Ventura's attorney, Mr. Wigdor. He says to permit this case to go into invasive discovery when we believe that the second Circuit, excuse me, will find the NYC look back is preempted. Now, this is a lot of legal jargon just to basically fighting for the fact that they want to stay on this and they want to wait until the issues with the Court of Appeals, the issues with the Second Circuit, all of those issues have been handled, which allows them, affords them rather, more time. He's also trying to get around this deposition, as I stated. Now, HARVE Pierre's attorney is piped up and they said, well, my client is not working. He does not have resources for discovery in this case. Is the case if the case is being thrown out, he says. So he does not have resources for discovery if the case is going to be thrown out. In other words, he doesn't have the resources to waste the time to deal with the discovery of this case, to pay a legal fees to be for the representation if this case is ultimately going to be thrown out. He says, we deny all of this. Her attorney piped up and said this grandstanding, he called it grandstanding, about a sealed case is inappropriate and irresponsible. And he says that, we have photos. He says we have photos. There is evidence of Mr. Combs's crimes. That's all I have to say, Your Honor, he says. Combs' attorneys came up and said, well, we take document preservation very seriously, so this is offensive. And the photo, of course, is the photo that everybody saw where that her attorney is referring to and showed in court. This is the photo where she is actually on his lap with her face sort of blurred out. Let's see if I can get this photo up. Let's see here. Yes. So I'll just bring this photo up because this is the photo that they're speaking of. Let's see. I think it's at the end of the document. Where is it here? Okay, here it is. I'll just share my screen so you guys can see it. But this is essentially, there we go. So it's this photo here that he's talking about. Her attorney is referring to where he says, well, we have evidence. This is the photo from the studio session at Daddy's house where she says that Mr. Combs asked her to sit on his lap to take a photo. This is a copy of that photo. And of course, she was 17 years old at the time. They began to ply her allegedly with alcohol and copious amounts of drugs. And you can see in the photo, Miss Kane she's wearing a skirt, but is literally around her waist, essentially. So this is the photo that they're talking about. And so Kane's attorney says that there is evidence of Mr. Combs's filmed his crimes. That's all I have to say. He said, we take document preservation very seriously. This is Combs's attorneys saying this. We take this very seriously. So this is offensive, he says. So that was kind of the end of that. I don't really know what the judge is going to rule. He will probably rule in writing. Normally how you saw you've seen rather Judge Subramanian rule. They'll argue it in court, but they will rule in writing what actually is going to occur, if there is going to be a stay or if they're going to move forward with the case in terms of allowing discovery to occur, which would give the plaintiff's attorneys, Miss Ann, Miss Cook, Miss Kane's attorneys, a time to gather discovery to find out who this third person is. Really, this is really them talking to different people. They have 7 people. They said already there are a slew, at least they said into the hundreds of witnesses and victims that they have access to that can help them not only ID this third person, but also prove up what actually happened and that this did actually happen in 2003. And of course, Combs's attorneys are saying, well, there's a lot, still looming around in the appeal circuit. We need to wait until that gets cleans itself up, and this, basically once we find that out, this will probably, the result will basically be that this case will be thrown out because this will sort of fix uh, what the issues that are happening in the Second Circuit will fix this situation here. So we'd rather just, pause this and wait until the issues in the Second Circuit are, discovered. So the judge is essentially asking for middle ground. Is there a way that we can ask for middle ground? What can we do? So we are going to wait and see what the judge says based upon what we heard and these three actually, because HARVE Pierre's attorneys, these three different takes on this situation. Okay, now let us move on to our final case of the day. Let's see here. And that is the case of, let's see, Misa Hylton. I always say Misa Hamilton. It's Misa Hylton. Goodness. And Mary J. Blige. Now, these two have a really long history together. Obviously, Misa Hylton was one of Kim Porter, Sean Combs's um, children's mother. Also, she was a former employee at Uptown Records, a former model, etc. Misa Hylton was one of Kim Porter's best friends. She and Mary J. Blige, who has enjoyed a very close relationship with Sean Combs. Obviously, if you know anything about the Uptown Record days and Mary J. Blige's career in general, Sean Combs literally gave her start. He created the persona that she has lived under or continue to enjoy a career under for the longest. Obviously, he was the sort of, engineer behind What's the 411, which is one of her first singles or first, I'm sorry, successful albums. She's had so many. And so Misa is a stylist. She, created the persona, the style that we know to be Little Kim. Same with uh, Mary J. Blige. I mean, she was a stylist for Mary J. Blige as well. So all of this is very circular. I'm mentioning this because obviously Misa Hylton is also the mother to Sean Combs' oldest son, Justin Combs, and she has a long history with everybody there. So a lawsuit between these two seemed really odd to me, but it is something that is going on. So let's talk about it now. Mary J. Blige is currently involved in a lawsuit filed by her former stylist and longtime friend, Misa Hylton. Now, Misa Hylton and the rapper goes by the name of Vado. They are seeking $5 million in damages for alleged interference with business relationships and emotional distress. Now, the lawsuit claims that Mary sabotaged Misa's management deal with this rapper by withholding his completed album and blocking his touring opportunities to force him to terminate his contract with Misa's company. Now, Mary has actually filed a motion, I think within the last few days. If I'm actually, no, it happened on July 29th. Um, Mary responded to Misa's lawsuit and she filed a motion to actually dismiss the case. And she called the lawsuit frivolous and utterly meritless. And that is the last that we've heard about this. I wanted to bring it to everyone's attention because I haven't talked about it before. But essentially, this is a really big deal. This is sort of, erring on the side of, friends don't make the best business partners. I'll tell you right now, I've had a few friends who are, performers, who are amazing artists who have asked me to represent them as a publicist. And I have said no each time. And the reason I have said that is because a friendly business relationship can be great, but once that thing sours, that thing stinks. And I don't mean stinks, it stinks. And so I, as a business practice of my own, I will not work directly for a friend. I will not represent a friend. What do we hear on I know y'all watch Sex in the City. Y'all don't pretend like you don't, because you do. But what did we hear that on Sex in the City, this and just like that, the reason why Sam Jones moved to London was because Carrie Bradshaw fired her as her publicist, and Sam Jones was embittered and pissed about it, and she moved to London, and they were really basically no longer friends. I mean, she sent the little funeral spray when Big died, and she, promised that she would meet up with her for a drink when she came to Paris to spread the ashes and all that. But Sam wasn't trying to be bothered with Carrie. I'm telling you, you cannot do business with your friends. That's just something I don't do. I know many of you guys do it, and God bless you guys who it's worked out for. But here we are seeing live and in living color that it is not working out. Now, she says that Mary J. Blige sabotaged a management deal that she had with Votto, that Votto had to break his management contract with her company, Misa Management, to sign with Blige's label, Beautiful Life Productions. So she is claiming that Mary J. Blige actually pressured Votto to break his management contract with her to sign with her management company. That's what she's saying. She's saying that, this is interfering with their personal relationship. She goes on to say that, Mary intentionally withheld Votto's completed album to prevent him from touring, effectively creating financial pressure to isolate him from Hylton, because she didn't want him to have anything to do with Hylton, because now you're signed to my company. These are the allegations. So she's seeking $5 million, that this was a breach of contract, this was emotional distress, and a torturous interference with a business relationship. And Blige's response again on July 29th, officially, she said that this was a frivolous, and that Hylton's company, Misa Management, is not even a legal or a valid corporation, she says. Whew, what a smack right there. That's I felt that shade all the way over here. Now, Blige has filed a motion to have the suit law thrown out, and she's accusing the plaintiffs, which is Misa's management group, of attempting to cause malicious injury and to stir up publicity. Oh my goodness, this is just so sad to see. Of course, um, this, I mean, it could get a lot worse, right? But this is just very spooky timing, if you will. Seeing as though what is going on right now with the Sean Combs camp, this timing is just very spooky. Oh my goodness, we're gonna stay on top of the Misa Hylton, Mary J. Blige debacle. That sounds messy. And again, guys, I'm telling you, being in business with friends can really be bad. I was being funny about the Sex in the City example, but it's really true. Like, I mean, we know the real reason that the real actress wasn't part of the series, and just like that. But in terms of the storyline, they played it exactly how it would probably go if a friend had to fire a longtime publicist, and that publicist was her friend, one of her best friends. It will probably sour the friendship. And this is the reason I don't rep any of my friends. It's just something I've never done, and I never will. Okay, guys, thanks so much for joining Cast and Court TV today. We will be back tomorrow with the latest and greatest, sometimes hated, woo woo. And we'll see you tomorrow. This has been your girl, Miss Public Info. You guys stay safe, stay cool, and stay out of trouble. All right, guys, we will see you soon. Thanks so much, guys. Peace.